everybody. Good morning. I'm Diego Arguelles. I'm a law professor at INSPER, and we are very happy today to have here for a book talk David Pozen, who is the Charles Keller Beekman Professor of Law at Columbia Law School. Hi, David. It's great to have you here. So Professor Pozen teaches on constitutional law, information law, and nonprofit law, among several other topics. He has worked in different branches of government before becoming a law professor, and this extensive experience in how legislators, judges, and policymakers work is reflected, how they operate in the US constitutional system is reflected in several of his innovative and challenging works on topics from transformations of transparency and separation of powers in the last few decades, just to mention two examples of his fields that I follow more closely. And in 2019, Professor Pozen won from the American Law Institute the Early Career Scholars Medal. This is just a very brief summary of his extensive resume. And we are very happy to have you here, David, for this talk on your recently published book, The Constitution and the War on Drugs, which, although is a book on constitutional law, history, and theory, and in the US constitutional tradition and system, it has so without further ado, David, I'll give you the floor, and just for people who are following us to know how it's going to happen. So first, Professor Pozen's book is downloadable for free via the link that we sent. And then I'm going to moderate. We're going to have Q&A. If you ask a question on YouTube, we can select your question from here. And once again, David, thank you so much for accepting to do this book talk here online with us at INSPER Law. And please, the floor is yours.
Thanks so much, Diego. It's a real honor to give this talk, and I look forward to your questions more than anything. So I will try not to go on too long, but also to provide a summary of the book, because I gather that I ought to do that. Not all of you will have read it. So maybe I'll spend 15 to 20 minutes trying to explain what the book does, and then it'll open up to your questions. So this is the book, and it basically tries to recover this historical moment in the United States, focused on the 1960s and 1970s, when drug rights were possible, when a lot of lawyers were making arguments for various kinds of protections for constitutional drug possession and use, and some courts were actually agreeing with their arguments. Even in the United States, even among constitutional scholars, I find this history is almost forgotten. And I want to see what we can learn from it, both about the regulation of drugs and about American constitutional law and comparative constitutional law. So the introductory chapter tries to drop us in on this moment in American politics and history when drugs were up for debate. And in the 1960s and 70s, as I described, the counterculture was in full swing. Rates of drug use, especially drugs like marijuana, were going way up in the United States. New political constituencies were mobilizing for drug liberalization. These included not only the hippies, but also college students, young professionals, and others. And you had a lot of mainstream civil society groups supporting drug decriminalization. You had, for example, the American Bar Association and the American Medical Association, and the National Council on Churches, and the National Council on Rabbis, and the Consumers Union, and all of these mainstream groups arguing that our drug laws were too punitive and searching for a new approach. And that created a window of opportunity for the courts to recognize limited forms of protections for drug users and possessors. And then the book chronicles how that happened. And it tries to emphasize in particular the trade-offs that courts confronted at all of these turns. A lot of these courts were sympathetic to claims that our drug laws were too harsh, but they worried about undermining the state's capacity to deal with public health problems and criminal law problems in general. So And I further try to set the stage by saying it's very curious that there is no discussion of drug rights in the United States right now for a few reasons. For one thing, there's a major social movement, a political movement for drug reform. A lot of experts in the United States now denounce the war on drugs as a calamitous and utterly counterproductive set of policies. So you have this new consensus that our drug policies really were destructive and futile. And you have a lot of efforts at the state level in particular to liberalize drug laws, like on marijuana legalization. Not only that, but some of the key themes and tropes of the American drug reform movement are things like individual liberty, racial justice, racial equality, and rational, reasoned government decision making. And those are the very themes that I see at the heart of modern American constitutional law. And yet, these reformers never invoke the Constitution. So they talk about how drug prohibition is bad for individual liberty, racial equality, and government rationality. And yet, they never refer to the Constitution, which covers that same ground. So why is the Constitution, in other words, sitting on the sidelines of this major social and racial justice movement in the United States, in a country that's used to having the Constitution at the center of those debates? That's the kind of puzzle that the book tries to work through. And then I'll just briefly describe the arguments of each of the chapters and the kinds of constitutional claims that were made in the 1960s and 70s and what happened to them. So I first look at claims that drug prohibitions, particularly for cannabis or marijuana, violate people's privacy or liberty, which in the US was understood to be protected by the Due Process Clause of the Constitution. And after the Supreme Court had recognized a constitutional right to privacy in cases like Roe versus Wade, dealing with reproductive rights, lawyers realized that there was an opening where they could make similar privacy and liberty-based arguments about the right to possess and use drugs, particularly in the home, because the court had recognized the home as a special zone of privacy in a bunch of these 1960s and 70s cases. And so you had this wave of litigation arguing that there's a privacy-based right to possess drugs. And in one famous decision, the Alaska Supreme Court accepted this argument and said that under the Alaska Constitution's right to privacy, along with the US Supreme Court's privacy precedents under the Due Process Clause, adults in Alaska really do have a right to possess small amounts of marijuana in the home, not necessarily outside of the home and not necessarily other drugs. But in what looks like a kind of proto-proportionality analysis, the Alaska Supreme Court weighed the infringement on the privacy interest against the state's regulatory interest in criminal bans and found that the balance cut in favor of a limited privacy right. The chapter then chronicles how that argument ultimately failed at the federal level. That is, the argument for a liberty or privacy-based right to use or possess drugs. And there, what the federal courts did is they basically, on my account, got scared that they had opened up the doors to a huge flood of claims for drug rights, right to ride your motorcycle without a helmet. That was litigated extensively in this period. Right to wear your hair long if you were in a government institution that prohibited that. All kinds of liberty claims. And they decided that they wanted to tamp down on this flood and try to control it. And so they developed a two-part test, which asks, whenever you make a liberty claim now, a substantive liberty claim under the Due Process Clause, do you have a fundamental right that was violated, a fundamental liberty right that was violated? If so, then you get very meaningful judicial review, strict scrutiny, and you're likely to win. But if you can't convince the court at the threshold that you have a fundamental liberty interest that was abridged, then you just get very light review and the government's policy is likely to be upheld. And this proved an insuperable barrier for drug rights plaintiffs or defendants because they were not able to convince any courts that they have a fundamental right to smoke pot. Maybe there's some privacy interest there's a liberty interest, but not a fundamental one, or at least no court would accept that. And so that's how all these cases were dealt with at the federal level. But at the state courts, I try to identify this more balanced approach, this proportionality-like approach, which recognized in Alaska and a few other jurisdictions limited privacy rights to possess drugs, at least in the home. The book then turns to arguments that the treatment of marijuana and some other drugs was so irrational that it violates the US Constitution's Equal Protection Clause. That clause had been read by the Supreme Court to say that all criminal classifications have to be at least minimally rational. They have to meet some minimal standard of logic so that when the government treats certain offenses in a certain way and other offenses in a different way, it has a reason. And what these claims argued in the 60s and 70s was marijuana was broadly classified as a narcotic or together with the heaviest narcotics throughout the states and at the federal level as the most dangerous of drugs with the total and complete criminal ban. And people argued, there's all this evidence that marijuana is actually less dangerous than other drugs like, say, heroin. And so it doesn't make sense that it's classified together with heroin in that drug schedule. Or they would argue, what's more dangerous than marijuana? Alcohol and cigarettes. And yet those aren't even classified at all. Those are legal for all adults to purchase. And so we've reached the point where the government has acted so irrationally in the way it's targeted marijuana that we have an equal protection violation. And to my surprise, I identified about 12 cases, about a dozen cases, where courts agreed with that argument. And they went through all of the evidence that had been coming out about marijuana's health effects, said that, look, there's some uncertainty. We can't say it's harmless or riskless, but the evidence does strongly suggest that it's less dangerous than other drugs like heroin or tobacco. And so we've reached the point where it's just irrational to give it this kind of treatment. And not only that, some courts went on and said, it undermines respect for the law. When young people in particular see this drug that they know from personal experience to be relatively benign, treated as if it were a killer, like, a heroin, that tends to degrade the integrity of the legal system. And so for that reason, too, some of these courts went along and said marijuana has to be removed from the most restrictive drug schedules, anticipating what the U.S. seems to be about to do, where President Biden has called for a rescheduling, and it looks like it may happen at the federal level. Of course, some states have already gone further. The book then looks at claims of racial inequality, and it documents how the drug war has had wildly disparate effects on people of color, particularly Black communities in the United States, even though white and Black Americans use and sell drugs at very similar rates. And it explains how challenges were brought arguing that this is racial discrimination, the fact that so many more Americans of color are arrested and incarcerated for drug crimes relative to the levels at which they're committed. And I explain how the court's race discrimination jurisprudence began to demand not just a showing of very different impacts across different racial groups, but also the specific intention to discriminate on the basis of race by the lawmakers. And although it's true that a lot of US drug prohibitions, including for marijuana, heroin, and cocaine, had racist motivations at the time they were first developed, by the time we get to the 1970s, the court said, no one's saying openly racist stuff anymore. They have legitimate public health reasons why they want to regulate these drugs. We cannot say that the specific intention of these drug laws is to oppress people from any given racial group. So even though they have these documented racial disparities, they don't violate the Constitution. Actually, it's even worse than that from people who think that these racial discrimination claims were really powerful, because then the court went on to say that what we demand from government laws and regulations is color blindness, that race not be taken into account at all. This is what the current U.S. Supreme Court has started to do. And whereas criminal drug bans never refer to race, they just say you can't use this drug or that drug. They never talk about the race of the people involved, although they have this differential impact. The only kinds of U.S. drug laws today that mention people's race as such are laws where drugs have been legalized, like marijuana, and there's an effort by some states to give special priority in who gets a business license to operate a dispensary or a store to historically disadvantaged racial groups. And those laws have been struck down. The criminal bans were not, but some of those laws have been struck down by some state courts on the ground that they give an explicit preference on the basis of race. And even though they're trying to be restorative, reparative, inclusionary in recognition of the harms visited by the war on drugs on communities of color, they're not colorblind. And so very perversely or ironically, if you think that historically disadvantaged racial groups should be protected by the Equal Protection Clause, the courts have started to do the very opposite in the United States. I'll try to be a little quicker. And then the book turns next to the U.S. Constitution's Eighth Amendment. It contains a prohibition on cruel and unusual punishment. Cruel and unusual punishment is forbidden. And what the courts start to say in the 1970s is one of two things. One line of cases argued and held that drug addiction cannot be criminalized in itself. There were some laws in the United States in the 1960s that said just the status of being a drug addict is itself a crime. And the Supreme Court said that's cruel and unusual punishment, to punish someone for a status that they have, which they might not even be able to control. Now, a lot of lower courts said, oh, if it's impermissible to punish someone for being a drug addict, then surely they've got to be allowed to buy and consume the substances to which they're addicted. But the Supreme Court stopped that move from being made by the end of the 1960s and said, no, really the only thing that is impermissible is targeting the status of addiction. And so this effort to build on that ruling and recognize that drug addicts get a special status under the Eighth Amendment was over basically by the 1970s. Another line of cases went further. It said there's a principle of proportionality in the Eighth Amendment that says that the punishment has to fit the crime to some degree, so that if it's grossly excessive, the prison sentence, in light of the moral gravity of the offense, that can also be cruel and unusual punishment. And a bunch of lower courts and state courts said when people are getting decades in prison for very low-level drug offenses like personal possession offenses, we've reached the point of gross disproportionality. And that is in some ways the most straightforward argument for constitutional drug rights in the US. You just can't punish people too harshly. And some types of drug offenses don't deserve decades in prison. But the US Supreme Court basically shut down that move by the 1980s and said, really, the focus of that doctrine is going to be on the death penalty, and almost exclusively the death penalty. And even life sentences for drug offenses are not going to be considered cruel and unusual. Finally, the book looks at arguments made under the First Amendment in the US. Some of these arguments were about religious liberty. And there's a famous case in California in the 1960s that said that the Native American church, which used peyote for sacramental purposes in its religious rituals, had a right to be exempted from the ban on peyote that otherwise existed in the state of California because the use of peyote was integral to its religious and spiritual practice. Lots of plaintiffs tried to get in on that and build on that argument and say, well, I also use drugs for spiritual reasons, or my church uses drugs for religious reasons. The courts were wary of those claims and everyone claiming a drug religion, and so largely limited that set of rulings to peyote and the Native American church. Other arguments were about free speech, and people said that they were using drugs as a form of political speech, like a form of protest. And the courts didn't really buy that. They said that if that's political speech, then lots of things we do are political speech, but people mainly use drugs for other reasons. We can't say that it categorically amounts to political expression. A more interesting argument, I think, is some people also started to argue that the right to free speech subsumes or includes or presupposes a right to free thought, what some people now call cognitive liberty, of the brain. And drugs, according to some people, stimulate creative thought and new ideas and sensations, and therefore a ban on certain types of drugs, particularly psychedelics, amounts to thought control, governmental thought control, which a long line of precedents had said is not allowed in the U.S. And the courts did not really buy that argument either. Although interestingly, it has taken off in the scholarly literature on drugs, particularly psychedelics, in recent years. And so I wonder whether that's going to make a comeback. And finally, and then I'll stop and hope we can talk about your questions. And I need to learn more about what the Brazilian Supreme Court has just done with marijuana. I'm very interested in that. I step back in the final chapter and say, what do we make of this jurisprudence overall, and where might it go from here? And I basically say, at the same time that U.S. courts were pulling back from recognizing any kind of drug rights, the rest of the world has actually moved in that direction. And this was even before the latest ruling came out of your court. I talk about a number of constitutional court rulings in Latin America, Europe, even a few out of Asia now, South Africa, finding that criminal bans, particularly on marijuana, violate principles of proportionality, and suggest that the U.S. Courts have a lot to learn from this. I further suggest that some of the U.S. state courts are actually doing a version of this already, and so may be more amenable to proportionality than the federal Supreme Court. And the structure of these rulings, and I haven't read the Brazilian one yet, and a lot of these courts is basically not to ask whether the right to use or possess drugs is fundamental, but just to recognize at the outset that there's some liberty, privacy, autonomy, or dignitarian interest involved in drug possession and use, which I think is inarguable. And then to turn to the government interest in prohibition. And that's where most of the analysis is. And the courts are increasingly saying there's just not a good public health case for a total ban on a relatively soft drug like marijuana. In fact, criminal bans on drugs like marijuana tend to create public health harms. Not only do they not advance the public health, they create a whole set of harms themselves, and they're criminogenic themselves. They also create a lot of problems with crime and corruption. And so that's the kind of analysis I think better captures the structure of the key argument for decriminalization of certain drugs that the U.S. courts haven't made possible with the requirement of showing a fundamentality. And that I argue we should learn from what courts are doing abroad in that regard. I also talk about other arguments that could be made in the U.S. based on the original understanding of the Constitution. Originalism has become a very trendy way of interpreting our Constitution. And I suggest that maybe surprisingly, there actually is support in the original meaning of our Constitution for some moves you can make to combat draconian drug laws. For example, there's all this new historical scholarship that the people who wrote the Eighth Amendment in 1791 actually had a pretty expansive view of what constituted cruel and unusual punishment, including long prison terms for nonviolent offenses. And if that's right, then if you're going to be a faithful originalist judge, you should actually strike down a lot of drug penalties as inconsistent with the original understanding of the Eighth Amendment. And I also talk about non-constitutional strategies and strategies people could pitch to audiences other than courts to argue for new types of drug protections. But maybe I should cut off there and move to the questions. Again, the spirit of the book is a historical recovery and critique of the U.S. turn away from drug rights in the 1960s and 70s, and then an exploration of how constitutional law has basically zoomed ahead of the United States and many other countries, now including Brazil, and what could be learned in this transnational dialogue. So Diego, I'll stop there, and so I can respond to everyone's questions. And Diego, can I ask, should I be drawing questions from the chat, or is there another method that would be better?
So Diego has some problems with his connection. So he asked me to step in. So let me introduce myself, David. My name is Guilherme Almeida. I'm also a professor here at INSPER. And I think that perhaps what I could do is I could read you some of the questions, and then we could have a chat about it until the time is up. But first of all, thank you so much for such a wonderful presentation and such a nice book. I was only able to read the introduction, but I'm really, really curious about the rest of the arguments. So the first comment that was posted to YouTube was by Larissa, and she asks, what are the most urgent changes you would recommend in drug policy to ensure it is more aligned with constitutional rights?
Great. I mean, my basic take on this is maybe kind of the standard liberal take in the U.S. Not sure it's so exciting, which is to rely much less on criminal punishment, and I would rely much more on administrative restrictions on drugs. And I'll explain a little bit more what I mean by that, and then talk about how the U.S. Constitution actually poses a problem there. So in my preferred world, criminal prohibitions would be used very sparingly, if at all, given their proven track record of not decreasing dangerous drug behaviors, but on the contrary, increasing dangerous behaviors and creating all kinds of negative second and third order effects, like the rise of organized crime and corruption, people not knowing the purity or even the nature of what drug they're purchasing, which creates all kinds of harms, and the way in which it's fueled mass incarceration in this country and the targeting of minority communities. So all of that suggests to me that the criminal approach is a failure. So what might be more promising? In constitutional terms, I would like to see the issue reframed around a right to health, which would, I think, have both positive and negative dimensions. So negative dimensions in that the state would not be allowed to apply excessively severe punishments to what are essentially personal choices or so-called victimless crimes. So that if someone's getting, decades in prison for a nonviolent drug offense, that would be struck down as an incursion on their negative liberties. But on the positive side, we would also have a requirement of governmental support for people struggling with addiction or drug abuse problems or mental health problems. A lot of the problems that we have in the U.S. with drug abuse occur most extremely when they interact with things like poverty, lack of access to healthcare, and lack of access to housing. So I think you really need a kind of a broad set of social supports for people's healthcare, housing, and income to allow for drug decriminalization to succeed and really advance public health. So I would combine positive and negative liberties under a right to health rubric. That'd be my preferred world. Here's where the U.S. Constitution comes back into the story as we move toward legalizing or decriminalized drugs like marijuana in this country in a way that I find pernicious. So my book focuses on how the U.S. Constitution failed to help. People kept enlisting it to try to resist draconian, racist, ineffective drug policies, and the Constitution didn't come to the rescue. It could have. The book tries to show the arguments were plausible, and some courts wanted to go there, but ultimately it didn't do it. And so we got the fully militarized war on drugs that we all know too well. But what if policymakers decide to legalize a drug like marijuana, as seems to be happening or may happen soon in the United States at the federal level? Here, the Constitution actually could do harm, in my view, for at least two reasons. Maybe three. I already mentioned it has been read by the courts to prohibit giving explicit preferences to racial minority groups in terms of who gets to profit from the legal businesses that are created. So that's one problem if you don't agree with the colorblind view of the Constitution. Second problem, once a product becomes legal in the United States, the court has said that there's very limited ability to regulate advertising. So once a drug goes from illegal to legal, companies can start going on TV and the internet and the radio, advertising and presumably targeting kids, who are the buyers they most want to get hooked early on. So my worry is that marijuana will get legalized, which I support, and then there'll be this just corporate advertising bonanza, which will be bad for adolescents in particular. And the First Amendment basically requires that, as it's been read by the U.S. Supreme Court, once a product has been legalized. And then finally, another part of the U.S. Constitution, the Commerce Clause, says that the federal Congress gets to control interstate commerce. And the courts have read that to imply that because the federal Congress gets to control interstate commerce, each individual state cannot do anything that interferes with interstate commerce too much. And the paradigmatic way in which you can violate that is by trying to support local businesses over out-of-state businesses too much. And so some states that have legalized marijuana don't want to have, like big tobacco for big marijuana, where you have these huge national conglomerates that dominate the market, undercut everyone, and try to hook kids on the product. They want to support local farms, local businesses. And those efforts have started to be struck down by the courts as a violation of the Commerce Clause. So, putting it together, it's like the worst of both worlds for constitutional, in my view. Not only did the Constitution not help attack criminal drug laws when they went too far, but it's going to get in the way if drugs are legalized like marijuana and people try to put reasonable restrictions on them and prevent a kind of big tobacco situation. So I would reframe around the right to health and relax those doctrines I just mentioned, so that if a drug like marijuana is legalized, there really could be significant restrictions on its advertising, for example, which seems to be like the much more sensible way to go.
Thank you very much for this. And if I can combine a couple of the other questions Larissa has posted in light of your response. One thing that is problematic, as you were mentioning, is that given the current framework, perhaps just the legalization of marijuana through legislative means might be problematic because of the issues regarding the regulation of free speech and the regulation of interstate commerce. But then the question that gets posed is, can the U.S. learn from the experiences of other countries that have recently decriminalized or legalized controlled substances like marijuana? What could be the strategy to try and overcome the difficulties that you mentioned? And finally, if we can tie in Larissa's last question, is that whether having a different system of taxation and other kinds of things could help allay the concerns that there will be big marijuana in the image of big tobacco.
Great. That's great questions. My answer is largely similar to what I said just before, in that I am not an expert on international or foreign or comparative drug policy. I've just studied the constitutional jurisprudence, so I don't purport to be able to tell you what's working best or not working well in other jurisdictions as far as drug control outside of the courts. But it is certainly my sense that an administrative restriction model has been more successful in other countries than the criminal model, that the U.S. applied in the war on drugs. And my, for example, limited understanding of what's happened in Portugal, often held out as the famous example of a total decriminalization jurisdiction, is that rates of dangerous drug behaviors have not gone up there as they have in other countries, or at least not disproportionately so, and therefore it's a modest success. We also have some precedents in the U.S., I should say. In the 1970s, 11 or 12 states, depending on how you count, decriminalized marijuana. For a brief window in the mid-1970s, we actually tried marijuana decriminalization, and the evidence suggested that the sky didn't fall. In those states in the U.S., there was increasing use of marijuana around the country in that period, I should say, but it didn't go up more in the decriminalizing states than it did in other states. So there was not evidence that just the fact of decriminalization led to a spike in use rates, and there weren't other serious problems that were documented at the time. So I guess I just want to say, I do think my limited understanding of the evidence, both from the U.S. and beyond, is that criminal prohibitions basically don't work. The instinct to use drugs is basically irrepressible. It's existed in almost all known human societies in some form. And kind of like the sex instinct, efforts to just outlaw it are almost doomed to fail and to create any manner of downstream harms. Better to try to pragmatically accept the reality of drug use and restrict it. Let me just say one, and I don't, but tax it, as you mentioned. Although I will say I don't think taxation alone would stop the consolidation of the industry and the way in which we make it a few huge companies dominating the market. And that's because they'll be able to absorb the taxes if they're imposed at the company level even better than smaller operators. And again, any effort to do something that I think you would have to prioritize small businesses if you were going to get around this problem. And that's exactly what states can't do on their own. In the US, however, the federal Congress could allow that. It can allow the prioritization of local business. So we could get a federal law in that direction. I'll make one more point, which is I think another aspect of responsible drug regulation would look at more than medical benefits. So in the US, the way that drug regulation works, the focus is on potential harms, like to the users in particular. And to the extent that anything else is considered at all, is there a recognized medical benefit? That's, for example, how the marijuana debate is playing out in the federal agencies right now that are evaluating its scheduling. What's missing from that regulatory calculation is the reason why most people use drugs, which is not actually for medical benefit, but for pleasure, or for a new experience, or relaxation, or a good time. I guess that's a version of pleasure. But all the kind of ordinary reasons why people use drugs, for adventure, alterity, insight, intimacy, friendship, sociality, all those things. I don't see why those shouldn't count in the regulatory calculus. I'm not saying they should be dispositive, but in other areas of regulation in the United States, we do cost-benefit analyses where we try to add up all the costs and all the benefits. And it seems to me like only in the drug area do we just ignore completely the benefits that people say they receive from a drug. And I think that's because of a kind of puritanical anti-drug ideology in this country that just either discounts to zero those pleasures, says that they're meaningless, or actually sees them as part of the problem, because that's why drugs are so seductive, that they are thought to elicit these pleasures, which really lead people astray. So I think it's very hard to quantify these benefits. There are a lot of challenges in figuring out just how to do it. But I think another aspect of responsible drug regulation would recognize the reasons why people say they use certain substances, and give them some weight in the analysis. Again, not dispositive weight, but I don't see why drugs alone should be a situation where we just ignore the benefit side and focus only on the costs. And of course, if you focus only on the costs of some substance, then prohibition is going to seem more sensible. But drugs are more complicated and throw off more benefits than just ones that can be reduced to a medical label.
Yeah, that's a very compelling argument. So I'll combine now two questions from colleagues at INSPER, Diego and Ivar, but I'll read them back to back, but they're connected. So let's start with Diego. Diego wrote, you say in the introduction that prohibition precedes policing. Problems of unfair, selective criminal processes and unequal application of the law can only happen after drugs are prohibited. But there are different levels of prohibition. The Brazilian Supreme Court has decided that individual users of marijuana cannot be treated as criminals. But the court maintained that it is still legal to possess marijuana in any amount. It is just that whatever sanction you suffer cannot be of a criminal nature. So it's still illegal. Sorry, I read that wrong. but you are still subject to other lighter sanctions. Would such a solution be enough in the US scenario? The inequality in racial discrimination deriving from prohibition would be solved if prohibition was not of a criminal nature? That's a question. And Ivar has a very similar concern. So in the Brazilian ruling, unequal applications of rules and enforcement of drug crimes was mentioned by justices as an important element due to the disproportionate negative effect on Black Brazilians. In the US, the SCOTUS at some point adopted disparate impact theory to offer better protection to Black citizens against the enforcement of laws that were colorblind in the abstract, but racist in the outcome of their application. Has disparate impact on Black people ever made its way into the debate about the war on drugs in US constitutional law? So those are the two questions. And then we have a very last question over email if there's time, but I know that we have a hard stop in 19 minutes.
I'll try to answer them relatively quickly so we can get to that extra question. Thank you. So I guess my view is that what I understand from the question the Brazilian Supreme Court to have ruled is better than the status quo in countries like the US, but still inadequate. So that is to say, drugs can still be outlawed so that there's no legal sale or possession, but the sanctions that are applied cannot be criminal in nature. I do think that's better in that criminal sanctions are a particular proven failure in this area and have obviously particularly serious costs for people's liberty. But it's also, I think, a somewhat incoherent regulatory regime. It doesn't address the issue of ensuring the safety and purity of the product that is bought. And since it's still illegal to sell and purchase, you get all of those issues about people not getting the drugs they think they're getting, and it's tainted, and all of the organized crime that tends to come with illegal markets. And you don't get the, I think, more effective efforts to regulate the product that come with the administrative approach, like taxation, age minimums to be able to buy, advertising restrictions, and so forth, and other public health support. So I view it as a kind of unstable equilibrium, that kind of decriminalization in between the criminal model that we've had and the public health model, where I'd like to see us go. In the United States, there was a commission that President Nixon, who on some accounts launched our war on drugs, he formed a commission with other conservatives. He handpicked 9 of the 13 members that was supposed to study the issue of how to deal with marijuana in particular. It was called the Schaefer Commission after its chair. And it shocked Nixon because in 1972, it recommended exactly what the Brazilian Supreme Court just ruled: decriminalization, no criminal sanctions, though you can otherwise prohibit this drug. So that could have become U.S. law. Then Nixon just ignored it, and so did Congress, and so that never became law. But just to say, that's often held out as a kind of attractive compromise, I think. But I don't find it fully satisfying for those reasons. The disparate impact question. So there, I'll just say maybe 2 things. So one, my book talks about how I think it's important to think about issues of racism and liberty and the like at the level of the decision to prohibit the drug in the first place, before we get to how that is enforced. That is to say, in the US, when people talk about the constitutional problems raised by drug prohibition today, they're almost exclusively talking about enforcement. That is, situations where the police go too far. They stop and search you without a warrant, sometimes called stop and frisk. They do racial profiling for who they target. They use surveillance in a way that's intrusive. They raid your home, and these are all very serious issues, of course, and they raise their own serious constitutional problems. But my book tries to argue they're all downstream from the first order question, which is, can you prohibit the drugs in the first place? And I try to show in the book, this mainly in the end notes, that people realized in the 1960s and 70s that if you allow a popular drug like marijuana or cocaine to be criminalized, how are you ever going to enforce that prohibition? You're going to need very invasive police tactics to do that. Why? Because when people sell marijuana or cocaine on the street, it's a consensual transaction. The buyer wants to buy that drug. There's no victim who's going to report that consensual sale. Not only that, drugs are small and portable and done all over the place. So basically, the only way in which you can get at these drug offenses under a prohibitory regime is if the police get in everyone's business, into their pockets and their homes, and you have basically a racialized police state. So I think if you think that's horrible and you don't want a racialized police state and you want police to lay off people, the better approach is to not allow criminal prohibitions in the first place. That's much more effective than efforts to rein in police once they're allowed to bust drug crimes all over the place. And that also goes to the first question, in that this is why I partly don't think that the decriminalized regime is fully satisfying, because even if police and prosecutors can't apply criminal sanctions, if it's still illegal to possess or use marijuana, then they can still use these invasive police tactics that have caused so much harm. On the disparate impact question, this got litigated in the U.S. with crack cocaine. So, and this comes up in one chapter in the book, but I'll give the brief story here, which is that, cocaine can be consumed in powder form or in crack form when mixed with baking soda and water, and it is smokable. Same drug pharmacologically in almost every way, but very different patterns of use in the United States. So in the 1980s, powder cocaine was associated with wealthier, whiter, suburban communities who used powder cocaine recreationally, as did a lot of people on Wall Street, and the finance community famously did that too. Crack cocaine was more associated with inner city Black users of the drug who basically had more access to the crack form than the powder form because of the way drug markets worked at the time. And so actually a majority of crack users in any given year were white in this country. But relative to powder cocaine, it was used more by Black people. But regardless, the rates of arrest and imprisonment were radically disparate across racial communities, so that throughout the late 1980s and early 1990s, in almost every jurisdiction I know of in the US, more than 90% of the arrests and incarcerations for crack cocaine were for Black people, even though, again, the majority of the users nationwide were not Black. Not only that, but Congress got so scared by crack cocaine that in a panic, in a series of laws starting in 1986, it said that crack cocaine would get punished 100 times more severely than powder cocaine by weight. So the same punishment would apply if you had 100 times more of powder cocaine than you had of crack cocaine. And this had horrible consequences for the Black community in the US and raised an obvious disparate impact. But this just goes back to what I said in my earlier remarks about how the court said, basically, that's never enough to win an equal protection claim. You always have to show this intention to put down a group on the basis of its race. And that's what can't be shown here. Yes, it's troubling, these figures of who's getting busted for crack offenses. But Congress had some non-frivolous reasons for thinking that crack might be more dangerous than powder cocaine. And there were Black representatives in Congress who supported those laws. And we have a hard time saying that they were racist against their own communities. So for me, this just shows the limits of a focus on discriminatory intent. This was one of the most egregious and obvious cases of a racially disparate impact I can think of, and yet the intent requirement proved an insuperable barrier. Unless the law refers to race on its face, which again, drug laws, criminal drug laws don't do. So this is one of these areas where I think drug law offers like a window into the limits and problems of U.S. constitutional law. The crack cocaine versus powder cocaine example is powerful evidence of that to my mind when it comes to race discrimination.
Okay, thank you very much. So our very last question comes from Tatiana Stocco, who's a professor of criminal law here at INSPER. Tatiana asks you about the anti-paternalist argument. So she says, based on the idea of a liberal state and the respect for the autonomy that many democratic countries ensure, including in the interpretation of their own criminal laws, how do you see the capacity of the anti-paternalist argument, that is not up to the state to punish its citizens for the harm they voluntarily cause themselves, to promote a significant change in the interpretation of courts regarding drug use? And she's concerned with any sorts of drugs, right? We know that your focus is mostly on marijuana and lighter drugs, but Tatiana is interested in the whole array.
Right. That's a great question. I guess my basic read of the U.S. case law is the anti-paternalist argument gets sidelined, and U.S. courts are too worried about that preventing all kinds of regulation of vice. Because if you really accept any strong version of an anti-paternalist argument, it would apply not only to people's drug choices, but also their sexual choices. And that was something a lot of courts, at least in the 1970s, when this was litigated, didn't want to do. So the classic version in the drug literature, is Mill's, the anti-paternalist argument is Mill's harm argument, that the only basis on which to restrict someone's liberty when it causes certain kinds of harms to third parties, to others. And that's a hard argument to make with drugs. You can, with some drugs at least, think about ways in which they may have negative effects on families or communities. I don't mean to dismiss that, but the link is pretty attenuated and not the kind of thing that would seem to fall under Mill's harm principle. And you had a lot of lawyers in the late 60s and early 70s basically trying to make a straight up anti-paternalist argument that if anyone is harmed by drug use, it is primarily the drug user themselves, but that's their concern. And we have a strong tradition of anti-paternalism in this country. It was alleged, and this is rejected. So I guess my short take on the U.S. jurisprudence is that that argument is plausible, but U.S. judges thought it proved too much because, in fact, they've always been selectively libertarian, selectively anti-paternalist when they support the causes at issue, and they've never actually really embraced Mill's harm principle, which I think in our interdependent, interconnected, modern society, judges thought was too hard or went too far, and they weren't willing to go there. But I think philosophically, that really is the most obvious argument against certain types of drug prohibition. Mill famously allowed for certain conditions under which paternalism was warranted, including when the person at issue lacks capacity to make reasoned decisions for themselves, like children. So you could still ban drugs for children, say. And Mill further said that certain choices that would so fatally undermine your liberty in future periods might also be prohibited, consistent with the harm principle. So what that suggests to me, and this comes up in the book at various points, is if there were a drug that was so addictive or so debilitating that even using it one time, although it would advance your liberty at the moment in the sense of you are allowed to choose to use it if you wished, ran the serious risk of robbing you of your autonomy in future periods, because you would basically be unable to stop using that drug once you started, or your mind would be so scrambled or your health so compromised from your initial use. I think that too would justify a total ban. But here I just want to note, no such showing is required to be made under US law or other countries' law as far as I know of. Just how addictive and debilitating a drug is isn't actually the question that US regulators ask. They just ask a much lighter question, whether it causes any harm. And while I'm no drug science expert, I do know from all the reading I did for the book that a lot of people think the class of drugs that rise to that level is very small indeed, and certainly wouldn't encompass something like cannabis. So anyway, that's a long-winded answer, which is just, I think what's revealing here is how the courts don't accept anti-paternalism really in the U.S. in this period when put to the test, even though they sometimes sound anti-paternalistic notes. Last thing I'll say is sometimes that gets argued in the U.S. Under the right to happiness, because in our Declaration of Independence, there was a right to the pursuit of happiness is named, and then 2/3 of the state constitutions in the U.S. explicitly codify a right to pursue happiness. So that might be a hook for people to argue. That was a hook when people tried to argue that you can't prohibit my drug use because it's part of my pursuit of happiness. You think it's bad or immoral, but that's paternalistic. And that basically, again, in the same period, gets shut down. In my view, anti-drug sentiment is part of what effectively erases the pursuit of happiness from the U.S. constitutional tradition, precisely because the commitment to anti-paternalism wasn't strong enough.
So, David, I experienced technical difficulties. I had to move to the background. So thank you, Guilherme, for assuming my role of the moderator. But I came back just to thank you very much, David, for joining us in this webinar today for the thoughtful discussion. And also thanks to people who are following us on YouTube and for the questions. And we hope to have you here in the future for other events, David. Good luck with the book.
Thank you. I would love that. And the comparative part of the book, we've only talked about a little here, but I'm interested in learning more and pursuing further. So I hope people will feel free to contact me if they want to keep discussing these issues. I would welcome that. And thanks so much again for having me and for the great questions.
Thank you. Thank you very much. We will keep in touch.
Great.